Verdict and answers can be reconciled. Just defer to general verdict B/C. We value jury system B. Verdicts with bench trials. Rule 52. 1. Rule 51. 1. The court is not permitted to return the equivalent of a general verdict. Court must find facts specially. Must write down facts. I feel differently about role of jury. To be voice of community with a general verdict. Jury brings opinion of community. To temper harshness of law. Judges are not voice of community and could just arbitrarily find for one party over the other. Finder of fact must find facts and not just sign someone else's facts. Trial judge is allowed to ask each counsel to submit proposed finding of facts and adopt some, but can't adopt the entire thing verbatim. Otherwise we wouldn't know how judge got to his decision. Purpose of 52. Leighton v. 1 William Street Fund, 2nd C 1965. 8. Appellate court by affording it a clear understanding of ground or basis of decision of trial court. B. Make definite what is decided by case, to enable application of preclusion to subsequent decisions. C. Evoke care on part of trial judge in ascertaining facts. 2. Roberts v. Ross, 3rd C 1965. Judge entered order for and told desk counsel to submit proposed findings of fact, conclusions of law and draft of judgment. Trial judge adopted S submissions verbatim after giving opportunity to file objections. You can't do that. Finder of fact must actually find the facts, not just sign someone else's facts. Trial judge is allowed to ask for each counsel to submit proposed findings of fact, but can't just adopt that shit verbatim. C. Judge does not need to enter judgment on the jury's verdict. 1. Judge may grant JMOL after the verdict. If no reasonable jury could have come to that conclusion, judge would enter judgment for the verdict loser. 2. Judge may order a new trial if the verdict is against the clear weight of the evidence, not as harsh entering judgment for the verdict loser. New trial. Rule 59. Judge may grant a new trial for any reason that has been used before. Minnesota Rule of Civil Procedure. Rule 59 has list of rules. 1. In the interest of the justice is not sufficient to grant a new trial. Minnesota Rule 59 provides specific rules which allow the judge very broad discretion in granting a new trial. Therefore, the reason must be within those reasons. Judge must give a reason for invoking the interest of justice. Harmless errors. Rule 61 should be disregarded, and a party should not be able to complain about an error unless prejudiced by the error. Magnani v. Troji, Illinois 1966, brought two different causes of actions. Widow and son must divide recovery from wrongful death claim, but recovery of other claim would go solely to widow. Jury gave general verdict finding for $19,000, but court doesn't know what proportion of $19,000 goes to which claim. Neither party realized. They need to ask jury to separate claims. Downloaded from outlineup.com. 32. 1. Within trial judge's discretion to grant a new trial. B/C. There was no other way to fairly resolve case. Only was prejudiced by mistake. B/C. It would have split her recovery, but only was complaining, and had even said to just award everything to her son. Complaining party was not prejudiced, so it was a harmless error. Rule 48. C. Allows jury polling at the request of the parties, or by the judge. In the event that during the poll, court finds that the verdict was not unanimous, the judge can order a new trial, or b. direct the jury back for further deliberations. 1. If jury is sent back to further deliberations, if it is possible that jury had good reason, that they actually redeliberated, then court must accept the second verdict. We assume that jury is obeying the rules, as long as the different verdicts could be harmonized on any reasonable theory. C. Kramer v. Kister, 1898, criminal case where jury agreed to a sealed verdict and separated. Next day, when verdict was opened, one juror dissented, and jury was sent to redeliberate, but came back with same result. 1. Judge declares a mistrial and orders a new trial. Concerned about coercion, no longer the rule. B/C. We have rule 48. C. D. Duck v. MGM Grand Hotel, 9th C 2003, modified comparative negligence jurisdiction. In original trial, relative degree of negligence of was 65% and was 35%, and jury award $3.3 million, but this was inconsistent. B/C was 50% negligent, so shouldn't have been awarded anything. Jurors get sent back, came back 20 minutes later and said was 49% negligent and was 51%, but still gave $3.3 million. Court orders new trial. B/C. Jury just wanted to get $3.3 million and just made up percentages that would work. New trial comes back with verdict for 1. Trial judge should have entered judgment on second verdict of first trial and thrown out second trial. We assume jury does what it is supposed to do unless it is absolutely irreconcilable. 2. If it is possible that jury had good reason, then court must accept second verdict. Assume juries obey the rules as long as different verdicts could be harmonized on any reasonable theory. Costly to have second trials. Respect for jury system and want to enter judgment on jury verdict whenever possible. 3. If jury returns a general verdict with answers to questions, but the answers were irreconcilable with general verdict, then under Rule 49, B. 3. Judge can either 49. B. 3. A. Disregard the general verdict and correctly apply the law to the answers. II. 49. B. 3. B. Ask the jury to reconsider its answers, or II. 49. B. 3. C. Order a new trial. IV. Rob v. John C. Hickey Incorporated, New Jersey 1941. Jury returned general verdict 4, but they also found that was contributorily negligent, can't award 4. If was contributorily negligent, NJ is pure contributory negligence jurisdiction, so two findings are irreconcilable. Judge orders a new trial. Trial court didn't just enter verdict 4B/C. There were two different parts of verdict, so judge found it fair to just award new trial for jury misconduct, things that jury can do that are illegal, and can cause judge not to enter judgment on jury verdict. Downloaded from outlinedupit.com. 33. I. Only for state court, using the quotient method of arriving at verdict, jury is supposed to deliberate until they decide on a verdict, supposed to be unanimous, and this method offends the unanimous deliberation. All the jurors agree on the method of finding the verdict, but not on the actual verdict. However, jurors are allowed to take an average as a starting point for discussion, just can't agree in advance that that number will be the verdict. B. Huckle v. Kimball, Kansas 1952. Jury used quotient method of arriving at verdict, decided they were going to come back for finding 4. Each juror wrote down damages that should be then figured out the average amount. 1. Quotient method is not permitted. Jury is supposed to deliberate until they decide on a verdict, and this offends the unanimous deliberation. II. Fed. Rule of Evid. 606. B. 1. Jurors are not permitted to testify/submit an affidavit. What happens during jury deliberations? Exceptions. 1. If extraneous prejudicial information was brought to jurors' attention. I. Did jury learn things from other things except for the testimony, that is from a newspaper article about the case? 2. If any outside influence was improperly brought to bear upon any juror, or I. For example, was the jury threatened or bribed? 3. If there was a mistake in entering the verdict on the verdict form. I. For example, all agreed finding for D but circles P, forgetting a decimal point. II. Mistake is failing to translate what all agreed on, not misunderstanding the instructions. B. Example where judge could not accept juror testimony. 1. Where jurors testify to using quotient method. 2. Where jurors said they misunderstood the instructions. 3. Where juror later changes their mind, that is juror says they regret their vote. B/C only agreed to it. B/C of pressure. 4. Reasoning for rule. I. Don't want jurors to be asked a lot of questions after deliberations. Protect them against badgering/harassment from losing party. II. Protecting the sanctity of the jury. III. Value of finality would be a big waste of time for the most part. 5. Reasoning against rule. I. Justice. Want to know whether the law was properly implemented. II. To get a new trial based on improper answers to a voir dire must show that 1. Juror deliberately gave a dishonest answer. 2. To a material question. And 3. That a correct response would have provided basis for a challenge. 4. Courts, McDonough Power, 1984. D. Additor and remitter. 1. Definitions. I. Remitter occurs when judge thinks jury verdict is too high. Judge will give the choice of 1. Accepting lower amount, or 2. Ordering a new trial. For example, if jury comes back with amount of $100,000, but judge thinks it should be $1,000, judge can offer to either 1. Order a new trial, or 2. Can take $1,000. B. If the judge is to use remitter, they can offer any amount within a reasonable range. Downloaded from outlinedupit.com. 34. C. Can never object to remitter. Rest need to agree for remitter to occur in the first place. 1. Objects to remitter on basis that it is not a permitted procedure. II. Additor occurs when judge thinks jury verdict is too low. Judge will give the choice of 1. Accepting higher amount, or 2. Ordering a new trial. Not allowed in federal court, only in state court. 2. Remitter is generally accepted, while additor is not. B/C under 7th Amendment we have to preserve the right of jury trial, and historical research suggest that remitter was a practice in 1791, but additor was not. I. Remitter can be controversial though. B/C. It undermines the jury system by saying the judge, not the jury, will decide what the damages are. B. Is the only party who could be upset by the remitter. B/C has agreed to accept the lower amount, but had no option in the matter. C. However, we uphold the practice. B/C trial judge has a lot of discretion in ordering a new trial. Trial judge could just say you should be happy I'm cutting it back to something reasonable, and not just denying a new trial, and you would be stuck with unreasonable amount. II. Additor is even more controversial. B/C remitter is at least awarding damages that was within what the jury wanted. Additor is going beyond what the jury decided. E. Timeliness of requests for new trial. Rule 59. Rule 50. Rule 50. B. Rule 6. 1. Appellate court cannot grant a new trial unless party has filed both 50 and 50 B motions. Otherwise, it is waived on appeal. 2. 6. B. Disallows time extensions to make 50 and 59 motions. Even if court grants the extension, it still won't be allowed. 3. 59. B. A motion for a new trial must be made within 28 days after entry of the judgment. 4. 59. D. Court may grant a new trial for any valid reason, even if it wasn't in the motion. F. Power to set aside a judgment on grounds discovered after it was rendered. Rule 60. 1. Correction of clerical errors. Rule 60. On motion or on its own, the court can edit clerical mistakes, oversights, or omissions, and issue a new judgment. For example, courts say enter judgment for $10,000, but clerk enters for $100 million. II does not include errors by the judge/jury. Only way to get rid of errors by law. Appeal. Most common. Or B. Use Rule 59. E. Motion based on an error of law, but they are rarely granted. 2. Time to file. Rule 60. C. I. Party gets a reasonable time to file, but at most 1 year for 60. B. 1. 3. This does not mean that party automatically gets 1 year for 60. B. 1. 3. It is just the maximum limit. 3. Mistake, inadvertence, surprise, or excusable neglect. Rule 60. B. 1. I. Almost always used for default judgments, which are disfavored. II. Only refers to mistakes of parties, not mistakes of law. II. Excusable neglect, mistake that is understandable that causes you to lose without trial. 4. Newly discovered evidence. Rule 60. B. 2. Trial is over, judgment is over, but party discovers new evidence that changes the face of the entire case. It creates potential to move for new trial. ***if within the 28 days, should just move for new trial under Rule 59. Downloaded from outlinedappet.com. 35. Any newly discovered evidence has to relate to something that existed at the time of the trial and could not have been discovered at the time of trial with reasonable diligence. The facts themselves have been in existence at time of the trial, but you were excusably ignorant of them. A video that was posted after trial, but was of P dancing during trial would be a reason to set aside judgment under this rule. B/C. 1. Video relates to facts that existed at the time of trial, but 2. It could not be discovered. B. But if P gets damages on the basis that he could never walk again, but then can miraculously walk, this will not be re-examined. 5. Fraud, perjury, misrepresentation, or misconduct by opposing party. Rule 60. B. 3. Perjury is a sufficient reason to set aside a verdict. B/C. Perjury is fraud. Must distinguish BTWN perjury and mistake. 1. It happens all the time that witnesses give conflicting evidence, but that's not perjury. 2. But if key witness knew that she was lying, then can be a basis. Hazel Atlas Glasgow v. Hartford Empire, 1944. S. Attorney participated in scheme to procure fake evidence for patent. Patent office issues patents, but they can still be claimed invalid if not first person to invent. To demonstrate that you were first, look to literature. Employees of patentee wrote an article saying how new and fabulous invention was. 1. Patent suit. Judgment set aside under 60. B. 3. B/C. This is just straight up fraud. Real bitch move. Peacock Records. INVV. Checker Records Incorporated. 7th C. 1966. Perjury is a sufficient reason to set aside a verdict under 60. B. 3. Perjury is fraud. 6. Fraud on the court. Rule 60. D. 3. Fraud on the court means that counsel is involved in the fraud. For example, if the lawyers are bribing judge or jury. B. If a witness commits fraud, it is not fraud on the court. There is no time limit to move for this. 7. Judgment is void. Rule 60. B. 4. Very rare. 8. Judgment has been satisfied, release, or discharged. It is based on an earlier judgment that has been reversed or vacated, or applying it prospectively is no longer equitable. Preclusion. Rule 60. B. 5. If in the middle of case, say need to get judgment based on what happened in a different case, but then judgment in other cases appealed and reversed. 9. Any other reason that justifies relief. Rule 60. B. 6. No one knows what this means. Cannot be something that isn't 60. B. 1. 5. Most likely applies to fraud by own counsel. Downloaded from outlinedappet.com. 36. Appeal. Generally a. 3 questions. 1. What is appealable? Issue of timing. When, at what time can you appeal to? What is reviewable? What can you get reviewed? 3. What is the standard of review? How does appellate court review a judgment? 2nd. Appealability and time to appeal. 28 U.S.C. 1291 Courts of decisions shall have jurisdiction of appeals from all final decisions. 1. The final judgment rule. Final judgment of the trial court. Ruling that ends the case. You must have a final decision, judgment, to take an appeal. Can't appeal in the middle of the decision. For example, a grant of summary J is appealable. B/C. It is the end of the case. But, denial of summary J is not appealable. B/C. Still have to go to trial. After final judgment can appeal that should had been granted summary judgment. Liberty Mutual Insurance Co. v. Wetzel, 1976, moves for partial summary judgment on issue of liability. Motion granted and 1. Appeals and appellate court affirms. Appeals to Scottus. Araforcoa to take appeal under a 1291 district court's ruling. Was not a final decision. B/C they found was liable, but hadn't yet answered question of relief. 1. Must have a final decision to take an appeal. At the end you appeal everything, not appeal each ruling. 2. Pro final judgment rule. Court doesn't want cases being split up and rulings being appealed separately. It's way more efficient to get all the ruling appealed together. B/C the rulings could affect each other and one appeal is more efficient than multiple separate appeal. The case will be strung out forever and the case would never be decided. Also, a lot of issues will drop out. If you wait until the end, the party that wins the case usually won't appeal interlocutory issues. 3. Against final judgment rule. Evidence could be lost/ruined/tainted by the time of the final judgment. Could avoid wasting time. That is if there's no SMJ. 4. Is final judgment of interlocutory appeal more expensive? Hypo. Final judgment system. Always $110,000. Interlocutory. Affirmed 80% of time. $120,000. B. Reversed 20% of time. Only $10,000. C. Expected total, $98,000. 5. States aren't bound by final judgment rule. That is, New York doesn't follow it. B. Judgment on multiple claims/involving multiple parties. Rule 54. B. 1. In a case with multiple claims or multiple parties, the district court can say what they have decided so far can be appealed. District court is not obliged to do this, but has the discretion to do so. District judge is in best position to decide if interlocutory appeal is appropriate. 2. Cannot be entered on issues, can only be entered on a claims. Downloaded from outlinedapod.com. 37. 3. Entering 54. B. Judgment. District court must expressly certify that certain counts are dismissed and therefore are appealable. Once something is certified for appeal under 54. B. The party must appeal it then, or give it up forever. 4. Sears. Roebuck & Co. v. Mackey, 1956. Mackey brought suit for 4 different things. DC. Dismiss counts 1 and 2, left 3 and 4 to continue. This isn't normally a final decision. B/C the counts dismissed are intertwined with the other remaining counts. In a case with multiple claims or parties, trial court can say what they have decided so far can be appealed. District court is not obligated to do this, but has discretion to do so. B/C judge is in best position to decide if interlocutory appeal is appropriate. C. Collateral order doctrine. Testing whether something is appealable before final judgment. 1. Is it a collateral order, not a question on merits of the case? 2. Is it important? 3. Is it effectively unreviewable later? That is, whether to post a security, whether someone should be released on bail. 4. Cohen v. Beneficial Industrial Loan Corp. 1949. Cohen brought shareholders derivative suit claiming directors had stolen money. Issue of whether had to post securities for costs of cases in case lost distance. Court says does not have to post security. Appeals. This is appealable, even though it doesn't seem like the final decision. Applied test for a collateral order that is appealable, even if it doesn't end the case. Collateral order. B/C not a question on merits of case. B. Important. C. Effectively unreviewable later, on appeal from final judgment. Point of security is, so S didn't have to wait until end of case to secure money from, and if they can't appeal now, they would be appealing at end of case, so would defeat point of security. 5. Problem with doctrine is that if you apply it straightforwardly, it will apply to too many things, therefore there are limits. Preclusion issues are not important enough to allow collateral order appeal, even if they are collateral orders which are effectively unreviewable later. Cannot appeal on discovery issues under collateral order. B/C once you turn it over, you can't get it back, would result in far too many appeals. However, if you refuse to do something, like turning discovery over, and you are held in contempt, then you can appeal. Practical compromise. Discovery matters will still not be appealable, but if you care enough to get a contempt citation and risk jail, then you should be able to appeal. D. Mandamus, 28 U.S.C. 1651. 1. Court of Appeals has power to order trial court to do something technically not an appeal, just a new case in Court of Appeals. Doesn't matter whether there is a final judgment or not. 2. Mandamus should be resorted to in only extreme cases. For example, when district court is usurping judicial power and there is a clear abuse of discretion, not to be used as a substitute for appeal, where appeal wouldn't be allowed. Courts are more willing to grant mandamus for new, important but unsettled questions of law. 3. Larby v. House Leather Co. 1957. District court referred a case to a master, private party to whom a case is referred for specialized reasons, like complex computations, and parties. Downloaded from outlinedapod.com. 38. Were not happy about this. S want to appeal, but not a final judgment, just said was going to send to master for proceedings. S sought rid of mandamus instead, order from Court of Appeals to trial court telling them to do something. E. Discretionary interlocutory appeals. 28 U.S.C. 1292. 1. Any interlocutory order that wouldn't be appealable under 1291, but judge thinks it should be appealable. 1292. D. I. District judge is not required to do this, entirely discretionary. 2. Orders denying an injunction. 1292. 1. I. Permanent injunctions are appealable under 1291. II. Preliminary injunction are appealable under 1292. Prelim injunctions are not appealable under 1291, but there is still a need to appeal these decision. B. But TROs are generally not appealable. B/C. They last no more than 14 days. 3rd. Reviewability. A. Appeal as of right. Rule 4. 1. Time for filing a notice of appeal. Rule 4. 1. I. 30 days to make an appeal from entry of judgment, not when judgment is issued. When clerk enters judgment into docket. II. 60 days if U.S. is a party to effective motion on a notice of appeal. Rule 4. 4. I. If a party timely files any of the following motions, then the time to appeal runs for all parties from entry of the last motion. JNOV. 50. B. Motion. B. Attorney's fees and costs are separate and don't have to be appealed within time. 3. Sometimes, timing for appeal can be extended for excusable negligence. Very rare. B. What is reviewable? 1. Errors must be in the record/party must have objected promptly. Preserve the issue. I. Can't raise something in Court of Appeals for the first time. Must have raised issue in district court. Seems harsh to refuse review of a dispositive issue on appeal, but it creates incentive to raise all issues at trial. Also, if it's a factual issue, may require a new trial, which is expensive/time consuming. 2. It must not be a harmless error. Rule 56. Didn't affect any party's substantive rights. I. Questions to consider. Does the error have zero impact on case? B. Does error cut in party's favor? C. Does error cut against party, but only had a trivial impact on case? II. Rationale reversal is expensive, and there will always be mistakes, so we can't reverse everything. Normally, if an error might be harmless, but appellate court cannot tell, then send it back for new trial. 3. If a party wants more money, then must take their own appeal. However, a party that doesn't appeal can take alternative grounds to court on other parties' appeal. 4th. Standard of review. A. De novo. Overruling based on law solely, even though it was a close call. Doesn't care about what the district court originally thought. Downloaded from outlinedappet.com. 39. 1. First Amendment issues require appellate review de novo, even if purely factual findings. 2. Rationale. I. These are questions of law, want people at top deciding the rules. II. Uniformity in rules. II. Court of Appeals judges are better experts on law. B. Abuse of discretion. If a matter is up to the district court's discretion, a court of appeals can review this under the abuse of discretion standard. It is deferential, but not infinitely deferential. 1. Efficiency concerns. C. Clear error. Overruling based on fact can only overrule if there is evidence that the district court ruling was indisputably wrong. Give deference to district court. Finding of fact can only be overruled if clearly erroneous. 1. Rule 52. 6. Doesn't matter whether distance court's ruling is based on paper evidence, that is there was a bench trial, or live testimony, jury trial, still review deferentially. I. Even more deferential to jury findings, overturn jury decisions, only if no reasonable jury could come out that way, like JNOV on appeal. 2. Rationale. I. Efficiency/cost concerns. II. Distance. Court is expert on facts, in better position. B/C. They are closer to the facts. Means they were also in a better position to make ruling. Downloaded from outlinedappet.com. 40. Preclusive effect of judgments. I. Stare decisis. Adhere to rulings from previous cases. Limits how often courts can change their mind. 2nd. Claim preclusion. Res judicata. A. Transactional test. Federal system. Rule 18. And majority of states. 1. Rule 18 permits parties to bring claim together, but not required to. However, parties really are required by transactional test of claim preclusion to bring all claims together. B/C can't bring claim again. 2. S are precluded from bringing a claim against the same that they could have brought if it arises out of the same nucleus of operative facts. Was it the same transaction or recurrence? 3. What counts as same transaction or recurrence? What is barred from bringing? I. Merger. If a party wins, the cause of action is merged with judgment. II. Bar. If party loses, the cause of action is barred, even if judgment is wrong. Finality. X. 7 Ps sue in federal court on federal antitrust claim. District court dismisses all the claims. 5 of the Ps appeal and win. 2 other Ps bring action in state court. It is removed to federal court. Supreme Court says, doesn't matter that judgment was already reversed. These Ps cannot bring the same claim again. B. Rationale. 1. This is necessary to prevent multiplicity of suits, burdensome expense, and delay to Ps, and vexations of litigation against Ts. 2. Ex post fairness. What is the fairest thing at this moment? 3. Ex ante fairness. What incentives will this have on future litigation? 4. Big cost/burden. 5. No reason to think that second judgment is better. 6. We want finality. If you could sue a second time, then there will never be finality. 7. If the rule was to adhere to the first judgment, only if it were correct, would have to start all over, and to determine if correct. 8. Gives parties an incentive to bring everything you have at one time. II. A claim is made on the set of facts, not on legal theory, therefore cannot sue on different legal theory from same accident with same, like suing for property damage, then personal injury, even if action doesn't arise until after first lawsuit. But from same transaction or occurrence still barred from bringing claim again, that is if get a burn, sue for it and win, and then get cancer from the burn, cannot resue for the cancer. IV. When you're bringing a claim for breach of K, you must bring the entire claim. Must sue for everything entitled B/C of the breach, and the rest is forfeited. That is if K has an unconditional acceleration clause, but P only sues for sum of damages, cannot bring case later for more damages. Exception. If the acceleration clause if not unconditional, then P may sue for only part of the damages and sue for more later, if conditional. Then the P has a right to sue for entire balance of the K, but they are not obliged to do so. Aglan. B. Rationale. We want to incentivize a P to bring all claims at once. Even if this is harsh, we want to conserve the system for what can bring. P can bring other claim against same D that come from different nucleus of operative facts. Downloaded from outlinedupit.com. 41. P is only barred from claims that they could have brought the first time. P sues D/Corp in state court and loses on state claims, but then sues D again on same facts. But for federal antitrust, this is allowed. B/C federal antitrust claims can only be brought in federal court. 1. Note, if it was the other way around, P would probably be barred from bringing the state law claim later, unless let in as supplemental jurisdiction. III. Contracts cases. K case, where the acceleration clause is conditional. B. Can sue separately as something is multiple case. Parties' own view of their relationship is determinative in a K case of whether something is a multiple case or 1K. 1. For example, you are lender on for bond and supposed to get interest payments twice a year. Basically have a coupon which is an IOU/note for the interest payment due. Can reassign the coupons etc. Borrower stops making interest payments. Lender sues when 6 coupons are due, but only sues for 3 of them. The rest can be sued for at a separate time. B/C it might be case that the rest are in someone else's possession. 2. Rationale. In contract law we want people to have personal autonomy, and this is the usage that has always applied to these coupons. These are multiple contracts. B. Primary rights test, alternative to transactional. Minority of states use this. 1. Bring a separate suit for each primary right invaded. Claim is no longer the set of facts. C. Defense preclusion. Claim preclusion for 1. Mitchell rule. If chooses to raise something as a defense that would have constituted a counterclaim, they cannot bring the counterclaim later as a new claim. 2. Lindemann rule. If chooses to raise something as a defense that would have constituted a counterclaim, they can bring the counterclaim later as a new claim. 3. Neither are that important. B/C we have rule 13. Compulsory counterclaims. Pleading must state the counterclaim if it is transactionally related, meaning defendant will be barred later. Therefore, Lindemann case arose today. D would have lost. B/C didn't raise the transactionally related counterclaim. B. Rationale. Efficiency. C. D may not like this. This is more unfair for the D than for the P. P got to choose the forum and takes full strategic advantage. However, D loses the ability to choose own forum for their claim. 3rd. Issue preclusion. Collateral estoppel. A. Prevents relitigation of issues that were 1. Actually litigated, and 2. Necessarily decided. Burden is on party asserting issue preclusion to go through record and show what was litigated in case 1. If record doesn't make clear what was decided, then party must bring extrinsic evidence. 1. Collateral estoppel applies as long as any issue is the same, even though causes of action are different. An issue of fact or law, actually litigated and resolved by a final valid judgment, binds parties in subsequent actions. Issue that is precluded is usually brought up in a later, unrelated lawsuit. II merely compels court to make same finding of fact that first court made on identical issue. 2. Why different rules for claim and issue preclusion? Downloaded from outlinedupit.com. 42. Claim preclusion provides incentive to bring all claims, but if we also required raising all issues, this would require a tremendous amount of effort. Plus, easier to know what claims might arise out of a transaction than to know how every issue in transaction may affect some other subsequent transaction. B. Actually litigated. 1. Issue preclusion applies to issues actually litigated and decided in case 1, not just issues that could have been litigated. Note that D in the first trial is not obligated to raise all of his defenses. Even if D could have raised a defense the first time, he is not collaterally estopped from raising them in another action. 2. Defaulting does not count as actually litigated. For example, in case 1, P sues you for breach of contract and you default. In case 2, P sues you again for additional breaches of the contract and you want to raise defense of no contract. Can you do this? Yes, it wasn't actually litigated. 3. Admitting something under Rule 30, deposition by oral examination, usually not considered actually litigated. C. Necessarily decided. 1. The first court's decision on the issue must have been necessary to the outcome in the first suit. Issue essential to the verdict. I. Outcome must depend on issue 2. Must be able to ascertain that the issue was necessary to the verdict. I. May be difficult to general verdict if a case involved a number of issues. 3. Basic test. I. If you change finding on issue, the judgment on case 1 would change. Yes, finding was necessary, gets preclusive effect. B. No, not necessary, does not get preclusive effect. 4. Refinement. I. In cases where it wouldn't change, what is the reasoning? If cut against judgment, finding was a negative thing for party that won first case. 1. Everyone agrees that both issues don't get preclusive effect. B. If neither finding cuts against the judgment, both good for party that won the first case. Each of the findings by itself would support the judgment. The alternative findings. 1. Restatement. Neither get preclusive effect. 2. Some courts. Both get preclusive. 3. Some do something in between. 4th. Valid. Final judgment on the merits. To get preclusion, case 1 must lead to a valid final judgment on the merits. A. Valid. Only invalid if defaulted. B/C of lack of PJ. 1. Does not mean that judgment had to be correct. 2. Doesn't matter if it didn't have SMJ. Can still have preclusive effect. I. Rationale. Party should have challenged it or appeal it. B. Finality is even more important than SMJ, which cannot be waived. 3. What if court in case 1 lacks PJ? I. If P showed up to and challenged or waived the claim, it is given preclusive effect. I. But if P defaulted, no preclusive effect. Only time judgment might not be valid. Downloaded from outlinedupit.com. 43. B. Final 1. If appealable, then also a final judgment for preclusion purposes. ACA resolve all claims as to all parties. 2. A judgment is still considered final, even if it is still on appeal. Appeals can take years. I. If you lose case 2 based on preclusive effect from case 1 that was overturned on appeal, you use Rule 60. B. 5. To set aside the judgment. C. On the merits. 1. On the merits is somewhat misleading, really means that there must have been an opportunity to get to the merits. I. If lost first case, but didn't lose on the merits, that is if didn't sue in the correct court, then not precluded. I. Sues for patent infringement. Case goes to trial. Trial leads to result upon which judgment is entered. Yes. Judgment on the merits. I. What if won on summary judgment? Yes. Summary judgment is still a determination. That case is so one-sided that doesn't need to go to trial. What if wins as judgment as a matter of law? Yes. Same as summary judgment. V. Sues for patent infringement. Judgment entered against for failure to prosecute. Rule 41. B. Deemed to be on the merits even though it isn't. Yes. B/C they had the opportunity to litigate the issue. We treat it as it was on the merits even if it wasn't. If it didn't get to the merits, it's the own fault. Therefore, claim preclusive effect. B. But no preclusive on issue B/C not actually litigated. V. 12. B. 6. Probably on the merits. P sues D for patent infringement. Dismissed for improper venue. P sues D again in same court. Still get preclusive effect for the point decided. Improper venue. P can relitigate just in a different venue. VI. If P and D have consent settlement, then claim preclusion. Preclusive effect on the claims that the parties agreed to settle. B. Issue preclusion. No issue preclusion. B/C wasn't actually litigated or necessarily decided. VIE. Default judgment did have claim preclusive effect. B/C claim was already litigated. Even though case 1 resulted from a default, it was on the merits. B/C had opportunity to get to merits, but chose not to take. Claim preclusion. X. No issue preclusion. B/C never litigated. V. Preclusive effect for whom? A. Privity 1. Having relationship with parties of a case such that it is appropriate to be bound by judgment. I. Success as an interest. Someone behind the scenes controlling case, but not actually a party. II. Not family or employer/employee. 2. Traditional rule. Only parties and anyone in privity to parties of case 1 can take advantage of judgment. A party could not be bound by a judgment in a case in which he wasn't a party. Unfair constitutional EP concerns. B. Contrary to principle of mutuality. Downloaded from outlinedupit.com. 44. 3. Modern rule. I. Claim preclusion. Same as traditional rule. Cannot have claim preclusion asserted against you/cannot assert it unless a party or in privity with a party to case 1. 1. Only assert it when same sue same. B. Due process and mutuality still arise. II. Issue preclusion. Abandons rule of mutuality. Still need to satisfy DP. Non-mutual defense of issue preclusion. Same different. Majority rule for states. 1. In order to be bound and have preclusive effect against you must be a party or in privity with party to case that produced the judgment. DP requirement. 2. However, new party can assert preclusive effect of judgment from case 1 against party in case 1I. This wouldn't have been allowed by traditional rule. B/C a non-party's incentive would be to sit back and let other parties litigate, then sue whoever loses case 1 assert preclusion and that party automatically loses. II. Principle of mutuality gives too much of a benefit to non-party. 3. Hypo. I. Case 1. A and B in car accident. A sues B after trial. B was not negligent. But turns out B didn't own car, but borrowed car from C, and under law C becomes liable for lending the car. II. Case 2. A sues C for vicarious liability. III. Barred by claim preclusion. No. Different defendant I've. Barred by issue preclusion. Yes. C can assert A's preclusion. That A was found to be not negligent. B/C of exception to rule of mutuality. 4. Hypo 2. I. Case 1. P sued for patent infringement. D1B/C patent was invalid. II. Case 2. P sues different D for patent infringement. D says no. Case B/C issue preclusion. III. Is due process satisfied? Yes. P was the party to the first case IV. Is there a mutuality issue? Under traditional test, yes. Now, no issue. B/C non-mutual defense of issue preclusion allowed. 5. Rationale. I. Claimant shouldn't get a second shot just by switching defendants. II. Claimant has already had a fair chance at this in case 1. If parties to case 1 are different than in case 2. 1. Who is bound to the judgment of case 1? Is due process satisfied? 2. Who benefits from the judgment of case 1? Is mutuality satisfied? B. Is there an exception to the rule of mutuality? B/C the parties in case 1 had an indemnification relationship. Downloaded from outlinedupit.com. 45. III. More efficient for the entire system. It is a waste of time and resources to allow them to litigate the issue again. 6. But there are limits. The district court must first check that the party had a fair opportunity to litigate the issue in claim 1. That is something about the forum. Case 1 was too small. If case 1 came out wrong. B. Non-mutual offensive issue preclusion. Different. Same. In federal system. Not majority rule for states. 1. This is also allowed. However, there are caveats. If T could have easily joined case 1, then D court can say issue preclusion isn't allowed. A. Is geographic distance enough? We don't know. If it would lead to inconsistent results. A. For example, bus accident. 1 sues bus company saying company is negligent. 1 loses etc. down to 20. But then 21 sues on same case and wins. P22-50 then should also win on this issue. B/C of issue preclusion. B. Due process problem. No. B/C bus company was a party. C. Mutuality. There is a mutuality problem, but 21-50 say mutuality has been abandoned. D. Rule. No. No issue preclusion allowed. B/C consistent judgments. E. Holding. This puts a lot of pressure on the bus company to settle. B/C and the chance that case 1 finds that the company is negligent, then P2P50 could just assert issue preclusion. 2. Problems that could arise with non-mutual offensive issue preclusion. It's a wait and see attitude. Therefore, it won't promote efficiency. B/CP has an incentive not join case 1. It could be unfair too. That is bad forum. Problems with inconsistent judgment. 1 could lose in case 1, but then 2 could win in case 2. Case the first of may not have afforded the same procedural opportunities as in case 2. Maybe didn't have best forum in case 1 etc. 6th. Interjurisdictional preclusion. A. Court in case 2 is bound to give judgment of rendering state from case 1 and must apply the same preclusion principles as rendering state in case 1. 1. Hypo. I. Case 1. Sues in Ohio. State court for property damages. Wins. II. Case 2. Sues in Cal. State court for personal damage. Says no. B/C claim preclusion. Can't split up claims. II. Decision is correct. B/C in Ohio. The rendering court doesn't allow claims to be split up. However, if it was the opposite situation, would be wrong. B/C Cal does allow claims to be split. B. Federal courts are bound by state court judgments pursuant to full faith and credit clause 1. If case 1 was decided by a federal court and case 2 is in a state court should apply federal preclusion principles. Unless it was a diversity case, then you apply state preclusion principles where the federal court sits. Downloaded from outlinedupit.com. 46. C. Court in case 2 must give the judgment from case 1 at least as much preclusive effect that it would have in rendering state.